Welcome to the introduction to the doctrines of law. This is a Smart Candy production brought to you by Upbeat Music, Media, and Ministries from Tallahassee, Florida. Just hit play and continue to listen. I'm recording this with voice because people learn different ways, and some people do better with audio and visual cues. So we're going to hit it from all sides here. The acronym law that we use as a word to represent, the body of statutes and rules that apply to a certain jurisdiction is actually an acronym for land, air, and water. And those are the three jurisdictions. Air is the highest jurisdiction. That is God's law, and what is derived from God's law is called trust law. And land is the jurisdiction of the soil, and that's where living men and women um, interact with each other, their property, and their rights as property. All of your rights are property. The W stands for the water jurisdiction, and that's where contracts, commerce, and statutory law, such as the Uniform Commercial Code and the Internal Revenue Code, derive their authority from. So whenever you are in the water jurisdiction, you are actually under the jurisdiction of the land and the air. When you are under the land jurisdiction, you are under the jurisdiction of the air. You're always under God's law and trust law. The first term we're going to go over is ab initio, and it simply means from the beginning. So when something is ruled or said to be effective ab initio, it means from the beginning of the contract or from the beginning of its existence. Actionable per se means that the very act is punishable and no proof of damage is required. Defamation and trespass are two class examples of torts that are actionable per se because you don't have to prove that you're damaged. You only have to prove that the action or that the act was committed. This is a long Latin word that I'm not going to read, but I am going to read you this. A personal right of action dies with the person. In other sense, if the man dies, his right to sue is gone. The burden of proof is on the plaintiff. So the courts are supposed to make the plaintiff prove their case, and if they can't, then defend it. There's nothing to prosecute. Whether this actually plays out in real life is a question of theory and opinion, I guess. An act done by me against my will is not my act. And this one is very significant because all contracts require voluntary consent. So if your signature or your consent was obtained on a contract against your will or under duress or under threat of violence or arrest or other legal action, then you didn't actually enter the contract. So if you can prove that you didn't, then this doctrine takes effect. This one says that an act does not make one guilty unless it is accompanied by a guilty mind or knowing intent. So in some cases, not all, intent is required to prove guilt. That guilty mind is often referred to as actus rea, and that is the intent, the knowing intent to commit the crime. So if you knew that it was a crime to do something and you did it anyway, then you were under the doctrine of actus rea. And here is the culmination of those. Conviction of a crime requires proof of a criminal act and intent, or an act does not make a defendant guilty without a guilty mind, or actus rea. It's also sometimes said to mean an act does not constitute guilt unless done with a guilty intention. So this is often applied. However, it's not often implemented. And I don't know if that makes any sense, but ad hoc is for the particular end or case at hand. So it's a statement that applies to this case or to this instance. Alibi is another place or elsewhere. So we've heard, my alibi is, I was in this other place when the crime was committed. I couldn't have been there. I couldn't have been present to commit the crime. Amicus curiae is a friend of the court or a member of the bar who is appointed to assist the court. In a lot of the patriot communities, an amicus curiae is a learned student of the law, not necessarily a bar certified attorney. And so friend of the court can mean someone who is learned in the law and can assist the court in making a decision according to the law or to the applicable law. Ante litem motum refers to statements made before suit was brought, before controversy instituted, or spoken before a lawsuit is brought. So it could be a prior arrangement or a prior statement made, a prior implication before the act that's being litigated actually occurred. Assentio mendium is the meeting of minds or the mutual assent. That's another word for coming to an understanding, a common understanding. Audi alteram partem means no man shall be condemned unheard. So that goes to your right to face your accusers and to speak in your own defense when required. Bona fide just means in good faith. It's a legitimate effort or a legitimate act taken in good faith. Bona vacantia means goods or property without an owner. Without an owner, it's actually not classified as property. It literally is simply goods. I don't like this one at all. Bona judice est ampliare jurisdictionem. It's the part of a good judge to enlarge his jurisdiction. If I don't know how much I should expand on this or not. I've got a lot of opinions. One of the reasons the lower courts usually look to their own jurisdiction is because of this maxim right here. It's often applied improperly and against the principles and laws of the higher jurisdictions. So it is the part of a good judge, and that's the key word right here, to enlarge his jurisdiction. Most of the lower courts are, actually all of the lower courts are not actually administered by a judge. And so when they move to enlarge their jurisdiction or find that they have jurisdiction, they're acting without jurisdiction to find their own jurisdiction. So a caveat is a caution registered with the public court to indicate to the officials that they are not to act in the manner mentioned in the caveat without first giving notice to the caveator. And so that would be in a contract action that they would have to notify the creditors before they took action on the property. Caveat actor means let the doer beware. So the person who does a particular act needs to be apprised of the risks associated with that act. Caveat emptor, let the buyer beware. So the buyer of a product should be apprised of the risks associated with the purchase of this or the obtaining of this thing that they're buying. And caveat venditor, let the seller beware. So the seller should be apprised of the risks associated with transferring ownership of this thing that they are selling. A certiorari is a writ by which orders passed by an inferior court is quashed. So when you petition, say, the Supreme Court for a writ of certiorari, you're asking them to review the case and quash the ruling of the inferior court. Communis hostis omnium. These are common enemies of all, or the common enemy of everyone, and that would be in reference probably to entities who act outside their jurisdiction. Corpus means body. So when you're talking about trust law, the corpus of a trust is the body of the trust or the bundle of rights and property that are being administered by the trustees. Corpus delicti is the facts and circumstances constituting a crime and concrete evidence of a crime, such as a corpse. It more commonly refers to the principle that a crime must be proved to have occurred before a person can be convicted of committing that crime. Corpus delicti is also indicative of the fact that every case, every contract is a trust, because corpus is a trust term to indicate the body of that trust, the body that's being administered. A corpus delicti indicates the body of rights, such as in the case of a dead body, the right to life, the body of rights that's being administered. Crimen trahit personam, the crime carries the person or wherever a person goes, and if he commits a crime there, then he will be covered by the provisions of that jurisdiction's penal code. And that applies to international law. If you commit a crime, if you're an American and you commit a crime in France, you'll be tried under the jurisdiction of France, under the penal code of France. Damnum sine injuria is damages without injuries. So this would be damages that didn't injure a person, but are still adjudicatable under whatever statute is being claimed. De facto means in fact or in actionable reality. So I'll wait till the next one to explain further, but our current corporate government is acting as a de facto government, so they are in fact governing. However, let's go to the de jure means by law, and by law, our de jure government is a republic, not a democracy. So the de facto government that's operating currently is the claimed democracy that you hear them talking over and over about in mainstream media. However, the de jure government, which is the lawful government, is a republic. It's a constitutional republic. And so that's how that's relative. De minimis means about minimal things. So this is imperative to understand because of the doctrine of capitis diminutio maximus and capitis diminutio minimus. The all caps name as opposed to the initial caps name and the significance of that. So this goes along with a lot of the other patriotic teachings out in the community. De minimis non curat lex, the law does not govern trifles or unimportant things, or the law is not concerned with small or insignificant matters, a common law principle whereby judges will not sit in judgment of extremely minor transgressions. A dictum is a statement of law made by the judge in the course of the decision, but not necessary to the decision itself. And this is a lot of times in the Supreme Court opinions, you have to separate the dictums from the actual precedents. Doli capax is capable of forming the necessary intent to commit a crime, which means they're of sound mind and understood the illegality of their actions. Doli incapax is incapable of crime or forming the intent to commit a crime. And that would be someone who's mentally incapacitated. That would be a minor in the case of a contract or breach of contract. And that would also be someone who is not capable of forming intent, which would mean a legal fiction, because a legal fiction cannot have intent because it has no mind. This is the tort of wrongfully holding goods that belong to someone else, and this is why living men and women do not sue public officials. We sue the men and women who hold public office because they are wrongfully holding goods, in the case of securities, that belong to someone else. A donatio mortis causa is a gift because of death, or future gift given in expectation of the donor's imminent death and only delivered upon the donor's death. So this is a bequeathment in anticipation of the imminent demise of the donor. Estoppel is prevented from denying. Estoppel is you can't deny me access to my offspring, or you can't deny me access to my property. That's what an estoppel is. Ex gratia is something done as favor or because of favor. Ex officio is done because of an office held. My original understanding of ex officio was done outside of the capacity of a public office or something like that. However, when I read these maxims and definitions, I learned that it's the exact opposite of what I thought. It actually means because of the office held. Ex parte are proceedings in the absence of the other party. So this is when attorneys get together and make a decision about the litigants without the litigants being present, and they're frowned upon. They're actually violations, but they actually do happen very often. Ex post facto means out of the aftermath or after the fact. It's a law that retroactively changes the legal consequences or status of actions that were committed or relationships that existed before the enactment of the law. In criminal law, it may criminalize actions that were legal when committed, aggravate a crime by bringing it into a more severe category, or change the punishment, like adding new penalties or extending sentences, alter the rules of evidence in order to make conviction more likely than it would have been when the crime was committed. And so our government is supposedly prohibited from issuing any ex post facto laws. However, in the case of the 14th Amendment, those the consequences of those things are actually ex post facto by definition. Falsus in uno, falsus in omnibus. False in one thing, false in everything. And I could go into this one for a long time, but I won't. Fatum means beyond human foresight. So if something is held as being in fatum, it means that it's unforeseen. Factum probandum is the facts that need to be proved, or the elements of whatever infraction need to be proved before a matter can be adjudicated. Factum probans is relevant fact, or a fact or statement of facts offered in evidence as proof of another fact. So it would be supporting facts. This one is important for us to know. It is fraud to conceal a fraud. And this happens to us on a daily basis in dealing with contracts that we were fraudulently, contracts that are fraudulently held. Or functus officio, no longer having power or jurisdiction, no longer having office over a matter, or no longer holding power or authority over a matter. Furiosi nula voluntas est, mentally impaired or mentally incapable person cannot validly sign a will contract or form the frame of mind necessary to commit a crime, or a person with mental illness has no free will. And this is why they will always ask for a mental evaluation if you refuse representation, because they want to prove that you're mentally impaired so that they can deem you a ward of the court. Furious absentis loco est is a madman is like one who is absent. So once they have deemed someone incompetent to manage their own affairs, they can manage their affairs for them as a ward of the court, or as a incompetent madman. And this one is a madman is best punished by his own madness. And I believe this is what the underlying doctrine for the innocent because of mental incapacitation theory. But it also gets utilized in some instances during the process of standing your ground as a living man or woman, usually by people who have formed criminal intent, and it requires an appeal to overcome this disability. The habeas corpus is a writ to have the body of a person to be brought before the judge. So this is the writ that is requested when someone is held in jail and you want to get them out. So you have a habeas corpus issued to have the body of the person be brought before the judge, represented or otherwise. Ignorance of a fact is an excuse, but ignorance of the law is no excuse. So you can claim ignorance of the facts, but you cannot claim ignorance of the law. Now, of course, you're purposely kept in the dark as far as the application of the law from a very young age, and that's by design, so that you purposely cannot function in law. Ignorance of the law is not an excuse, or ignorance of the law excuses no one. One unaware of the law may not escape liability for violating that law merely because he was unaware. So you can't go in front of a judge and say, I didn't know it was against the law. I mean, you can, but it's not going to help you much. So it behooves all of us to learn the law and understand what law is and what law is not, because there are things being imposed upon us as law that are not laws. Injurious sign damnum is injury without damage. We went over previously about damages without injury. This one is injury without damage. Ipso facto means by the mere fact. So if something is said to be ipso facto, it's because it just is. Impromptu as opposed to impromptu. Impromptu, we all know impromptu to be meaning, suddenly done. But impromptu means in readiness. So you are prepared to do something. In personam is a proceeding in which relief is sought against a specific person, or a specific man or woman. Innuendo is spoken words that are defamatory because they have a double meaning. So if something is defamatory, an innuendo would imply a set of facts that are not specifically spoken because of the innuendo in the statement. In status quo is in the present state or as things currently are. Inter alia is something that you see often in contracts and legal proceedings that means among other things. So it's a reference to other things not stated. Inter vivos is between living people, especially of a gift as opposed to a legacy. So this definition was taken from the website of a law student website. It's for students of the law, and this actually speaks to the slant that they're educated to cover and to understand things from a statutory perspective as opposed to a lawful perspective. Because inter vivos means between living people, and that's the end of the definition. So when this other part is especially of a gift as opposed to a legacy is added, that is the reference to kind of guide the understanding of the word inter vivos to being especially of a gift as opposed to a legacy, as in like a probate issue or that sort of thing. But the definition of inter vivos is between living people, and that's it. The other part is not necessarily relevant. It is in the interest of the state that there should be an end to litigation. So sometimes we feel like our matters are dragged out and drawn out and unnecessarily prolonged the agony of litigation. And this is actually a maxim that you can present to get a final adjudication and end the matter. How effective it'll be will depend on your presentation. Jus cogens or is cogens is compelling law, and this is a reference to precedent or precedent or a higher form of law in reference to the matter at hand. In jus personam is a right against a specific person or party, and it's seen often in contract, as in probate or other where the parties are adverse to each other and have rights against each other, like spouses or ex-spouses and that sort of thing. Jus in rem is a right against the world at large, such as the right to be left the hell alone. That's a jus in rem right. Jus naturale is natural law, or a system of law based on the fundamental ideas of right and wrong, based on the laws of nature and nature's God. If that term sounds familiar, it should. Jus necessitatis is a person's right to do what is required, for which no threat of legal punishment is a dissuasion. This is the doctrine of necessity, or a person doing a thing under the compulsion of a situation who is not capable of committing a wrongful act because they had to do it. For instance, stealing food to eat because you can't eat, or stealing food to feed your baby. There should be no legal punishment. That should not be a crime because of the doctrine of necessity. Jus non scriptum is customary law, or laws as by custom. So in countries where they have Sharia law, those laws are set by custom, not international law. So some of their exceptions to international law are claimed by the doctrine of customary law. Jus scriptum is the written law, and that is precedent law. The law that is written somewhere. we use Jesus used it. He said it is written, so he was using jus scriptum when he was saying it is written. He was using the written law. And jus simply means the law or the right. So when you see jus used in a term as the precursor to a word or as part of the word, that's what the etymology of it means. Justitia nemini neganda est is justice is to be denied to nobody. No one is to be denied justice. Happens all the time. However, the system is supposed to prevent that from happening. Jus soli is the right of the soil or the law of the land. the Citizenship Clause of the 14th Amendment, allegedly ratified in 1868, because I don't believe that it was ratified. It says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. What it neglects to point out is that they are a state citizen is in the corporate jurisdiction of the corporate fiction that's called a state. However, they have the rights of the land that they were born on, and that's just solely the right of the soil or the law of the land. Jus sanguinis is the right of blood or descent, and this is more common in other countries that actually the United States is really the only one who uses the previous jus soli to provide citizenship. Most countries consider nationality according to the doctrine of jus sanguinis. Lex fori is the law of the country, the law of evidence, or the law of evidence is the law of the land where the court proceedings are taken. So whenever they're considering the requirements for evidence, they consider the law that is relative to that geographical jurisdiction. The law must not be violated, even by the king, or we can read it as even the sovereign is subject to the law. That is the land, air, water, the acronym for the word law, which actually means the jurisdictions of the land, air, and water. Locus standi is right of a party to an action to appear and be heard by the court. So you have the right to appear and be heard by the court and face your accusers, know the nature and cause of the action, that sort of thing. You have the right of a party to an action to appear and be heard by the court. So you have the right to not have things adjudicated in your absence. Malafide is in bad faith. That's when something is done in bad faith. And many, many, many things are done in the judiciary system in bad faith, basically to achieve their objectives without considering the needs or the situation of the people who are being adjudicated against or on. Malum in se or mala in se is wrongful or evil in itself, and it's a term that signifies a crime that is considered wrong in and of itself. And most believe that murder, rape, and theft are wrong, regardless of whether a law governs the conduct or the location of the crime, and so those crimes are considered malum in se. Malum prohibitum is the opposite of malum in se. It means the crimes are criminal not because they are inherently bad, but because the act is prohibited by statute. So if you are putting a sign on your fence in a jurisdiction that has a statute that says that it's a crime to put a sign on your fence, it's not a crime because it's wrong or because it's bad or because it's immoral or because it hurts anybody. It is considered a crime because it's prohibited by a statute. And this is where we need to understand jurisdiction, because statutes in a lot of cases do not apply to us. Mandamus is we command. It's a writ of command issued by a higher court to government and public authority to compel the performance of public duty. And in some cases, a mandamus is written by the sovereign to the court. In some cases, a petition for a writ of mandamus is where a sovereign asks the court to issue a writ of mandamus to a lower court. Mens rea is the guilty mind or the criminal intent. So if someone has the capability to form a criminal intent, they are said to be acting in mens rea. A misnomer is a wrong or inaccurate name or term, such as referring to a living man or woman by a corporate title. Modus operandi is a way of working or a mode of operation, the way things are done around here. Modus vivendi would be a way of living. In some cases, a modus vivendi would be the prepper's lifestyle, where they live off the land and they're off grid. Or a modus vivendi may be an opulent lifestyle, where someone lives in a high-rise apartment on Fifth Avenue. That is their modus vivendi, their way of living. Mutatis mutandis is with the necessary changes having been made or with respective differences having been considered. So mutatis mutandis is sometimes necessary to have a meeting of the minds because certain concessions have to be made. So you have to consider the mutatis mutandis to move forward to the eventual meeting of the minds. Sometimes the mutatis mutandis can be a sticking point, and sometimes it is handled and moves past point by point to reach a profitable end for the parties involved. This one should look familiar to you. It says, no man can be twice punished for the same offense. The doctrine of double jeopardy is actually a foundational principle of law. It's a trust term, or it's a doctrine of trust law. And these terms that I'm using, they apply in all three jurisdictions. So no man can be twice punished for the same offense unless he commits it again. So, and no man can be the judge in his own case. So nemo moritoris presumitur mentire means a man will not meet his maker with a lie on his lips, or no man at the point of death is presumed to lie. And this is the dying declaration doctrine, so that a dying declaration is taken as truth when it's spoken in the moments before death. Nobody can be both landlord and tenant of the same property. This one is important for homeowners who are trying to discharge their mortgages. Your mortgage lists you as a tenant of that property. So you need to find out who in the heck is the landlord. A nolle prosequi is a formal notice of abandonment by a plaintiff or prosecutor of all or part of a suit. This is a decision not to prosecute. Novation is a transaction in which a new contract is agreed by all parties to replace an existing contract. So when there's a meeting of the minds and an understanding, they will put a new contract in place and nullify the previous contract. There must be no crime or punishment except in accordance with fixed predetermined law, or there must be no punishment without a law existing to define it as a crime and to define the punishment for said crime. Nunc pro tunc means now for then. A ruling nunc pro tunc applies retroactively to correct an earlier ruling. So a nunc pro tunc is different in ab initio, because ab initio means that it's effective all the way to the beginning of the contract. A nunc pro tunc would be to nullify a earlier ruling now for then to correct whatever action was taken at that time, which will be the beginning. But there is a distinctive difference between nunc pro tunc and ab initio. They do not mean the exact same thing. They're just very similar. Non sequitur is a statement such as a response that does not follow logically from or is not clearly related to anything previously said. In other words, it's irrelevant. Obiter dictum is things said by the way, and it's generally used to refer to an opinion or a non-necessary remark made by a judge. It does not act as a precedent. So basically, it's just something that they said. It's not actually considered in, cases to be like the law of the land from a Supreme Court judge. It's just a comment that they made. Refers to a passage in a judicial opinion that's not necessary for the decision of the case before the court. So it would be like when they state an example or something like that. It's an obiter dictum, but it's still a part of the dictum that they're giving for the opinion. It's part of it, but it's not necessary to be considered precedent. Onus probandi is the burden of proof. So pacta sunt servanda means agreements must be kept. They're legally binding, and in international law it means that every treaty enforces binding upon the parties to it and must be done by them in good faith. Pari passu, I think I'm pronouncing that correctly. Pari passu is with equal step or on equal footing, and it's sometimes translated as ranking equally, hand in hand, or with equal force, or moving together. And by extension, it means fairly or without partiality. Participips criminis is a particular or a participator in the actual crime or a partner in crime. Per curiam is by the court or decision made by the court or a majority of the court acting collectively. Per curiam. Per se means by itself or of itself. Persona non grata is a person who is unacceptable or unwelcome. In diplomacy, a foreign person who's entering or remaining in a particular country is prohibited by that country's government. So persona non grata would also be, in the case of a contract, would be an interloper or a person who is interfering in a matters adjudicated, and they don't have standing as a party in the case. Prima facie is at first sight or on the face of it. So when people say prima facie evidence, like a document is prima facie evidence of a contract, that means that you look at it, there's a document, it's a contract, it's got this requisite signatures and the other elements of a contract. So at first sight, it is an actual agreement. Alimony is a husband or wife's provision for a spouse after separation or divorce, as opposed to palimony, which is money a man gives to a woman with whom he has been living and from whom he is separated. Palimony is not usually used in the United States because it has a slightly different meaning in different jurisdictions and different countries. Per curiam is another word for by the court or by a court, as opposed to per incurium, which is because of lack of care. The quantum meruit is what one has earned in the amount or the amount he deserves, a reasonable sum of money to be paid for services rendered or work done when the amount is not stipulated in a legally enforceable contract. So if someone says that they should be compensated for doing something that they had no contract for, a quantum meruit would be the amount that's determined that they are entitled to. He who acts through another acts as himself. The doctrine of agency or representative capacity, vicarious liability, as in the employer-employee relationship. A wrong done when drunk should be punished when sober. So someone is convicted of drunk driving, they will spend the time paying for the punishment during their sober time. A quid pro quo is something for something or something done for something with the understanding that something else will be done. I hope that's clear. He who receives the advantage must bear the burden. So he who is getting the benefits of the contract must bear the burden of the obligations of the contract. Quo warranto is by what authority? This is a writ calling upon one to show under what authority he holds or claims a public office. This one has been used very effectively by those who know how to write a request or how to write a demand to show authority. That's another thing that people are calling this. A quo warranto is also a demand to show by what authority you claim to rule. Necessity knows no law. This goes back to what we were talking about, stealing to feed your children. If it's done by necessity, there's not a law to punish acting out of necessity. Ratio decidendi is the principle of reasoning underlying a court judgment or the rule of law on which a judicial decision is based. And respondeat superior is the doctrine of the master-servant rule. Let the master answer or let the sovereign answer. Employers are liable for acts of their employees when they're under their employ. It also is let the principal answer in contract law or in securities in the finance world. The thing speaks for itself. So this is basically it is what it is. The facts are easily ascertainable by looking at the act or the circumstance or the set of circumstances around a thing that speaks for itself with or without evidence. Res judicata is a matter already judged. It's a matter that's finally decided by a competent court on the basis of merits. Res judicata pro veritate accipitur. A judicial decision must be accepted as correct. The key operative word is judicial. Many of the what we consider court decisions are not actually courts, and they are not presided over by a judge. So their decisions are not judicial decisions, and they can be challenged because they are not judicial. They're they may have been a judge at one point, but they're acting under their capacity as an administrator. And administrators' decisions can be challenged, and they can be determined to be incorrect. Y'all, this is an actual legal precedent. It's a law maxim. The king can do no wrong. It also can be said that the sovereign can do no wrong. may help you understand it a little better. In this house, that cat is apparently sovereign, and she can do no wrong. So if she gets in the camera, then it is what it is. You want to say hello, Mittens? She does not, and that can not be wrong because she is the king. Suprema lex salus populi. The welfare of the people is the supreme law, and it means that the public welfare is the highest law because the government is actually a public trust. So it every statutory provision made by this legislation has to fall under the rulings and fall within the confines of trust law. Ideally, it doesn't, but ideally it would fall under the confines of trust law for the beneficiaries, which are the living men and women on the land. So sine die is without day or indefinitely. And this is, you've heard this term in reference to when Congress was adjourned, sine die or without day. It means it was adjourned indefinitely, and then the de facto government, the corporate government, came in and took over because we, living men and women, were not populating our de jure government properly like we're supposed to. However, that's changing. Sine qua non means without which nothing. It's an essential condition, a thing that is absolutely necessary, and it's a component of an argument that, if debunked, causes the entire argument to crumble. So, a sine qua non, an example of a sine qua non would be to be convicted of a traffic offense. I would have to be found to be operating in commerce, which traffic is commerce. And so an essential condition would be that I was operating in commerce. Suo motu just means on its own motion. I don't know exactly what you would use a suo motu, or where you would see a suo motu, because a court would be a sua sponte action, but on its own motion, suo motu. Liberum fides is utmost good faith. And boy, I spelled that crazy, didn't I? But anyway, the utmost good faith is a fiduciary duty. This is a requirement of a fiduciary in their role as a fiduciary or as a trustee of a trust. They have this level of responsibility. Ubi jus ibi remedium. Where there is a right, there is a remedy. So this is a doctrine. So this underlies the system that is in place, and it's supposed to function with the understanding that where there is a right, there is a remedy. We have been deprived of that remedy for many, many years. However, things are slowly being put back into place to function correctly. A veto is a ban or order not to allow something to become law, even if it has been passed by a parliament. And in the precepts of trust law, a veto would be a ban or order not to allow something to become a law as it pertains to that set of statutes or that set of rules or that jurisdiction. Vice versa means reverse position. A vis majora is an act of God, such as a weather event or some unforeseen act of God. So you see this term sometimes used in insurance contracts and that sort of thing. Volenti non fit injuria, damage suffered by consent gives no cause of action, or harm caused with consent cannot be considered an injury. And so consent is actually the operative word here in our case in a lot of the contracts that we're held to, because our consent was obtained fraudulently because it was obtained under duress, coercion, or threat. The vox populi is the voice of the people, or the opinion of the majority of the people. A waiver is voluntarily giving up or removing the conditions, or voluntarily giving up or removing your entitlement to a right, which a living man or woman cannot waive many of their rights. You can, however, waive the conditions of a contract. And so understanding contract law and how it affects us and how it's been made to be the operative form of law will help us to overcome the implication that we have waived certain rights.